That was Employment Law 2019. We would like to summarize the 3 most important changes of the last year. Ms. Winter is the head of HR. In 2019 as well, there were court decisions and legislative changes that affected many aspects of her daily work. With her lawyer, Mr. Foster, she reviews the key changes of the year. One of them came from the European Court of Justice. It passed a decision that all companies must introduce a system for complete working hours recording. Until recently, it was only required to record specific working time. After that decision, Ms. Winter's boss was very worried and asked whether from now on all employees would have to use a time clock. Mr. Foster calmed his client. For now, there is no concrete action required because the Bundestag would first have to pass a corresponding implementation act. Mr. Foster will inform Ms. Winter as soon as further measures become necessary. The new Trade Secret Directive finally became effective. This is a law to improve the protection of confidential business information, but it also changed the regulation on handling whistleblowers within a company. For such employees, a reporting system must be made available soon. The rules on terminating the employment with whistleblowers are also stricter now. Discrimination is entirely forbidden. At the same time, the guideline specifies an exact sequence of actions for informers. Irregularities are first reported internally or submitted to an authority. Only after that, an informer has the right to address the public. Mr. Foster recommends keeping an eye on the legal situation at all times and planning reporting systems early. Of course, he will assist Ms. Winter with this every step of the way. Regarding job service and placement, there was also an important decision. The Federal Labor Court decided that a move of a terminated employee to an in-company employment and qualification unit, or BQE, is considered a transfer and is therefore subject to a prior approval by the Works Council. Ms. Winter's Work Council then tried to block upcoming qualifications and exercised the right to refuse approval. Mr. Foster offered Ms. Winter several solutions. For one, the withdrawal of one employment relationship without assignment to another as well as the release from work during the termination period do not constitute a transfer. If it is necessary, nevertheless, to move the employee to a BQE, it must be ascertained that this is only a training or continued education measure without additional work responsibilities. Otherwise, Mr. Foster recommends using an external provider. Here as well, the Works Council does not have to be involved. Ms. Winter is relieved. Mr. Foster is a competent partner who is always there to assist with issues of employment law. Would you too like to benefit from the sound advice of our lawyers? We will be glad to help.